Hi, Attorney Julie Paquette, joined today by Attorney Nicole Laruwe. We are both probate and estate planning attorneys, and today we are shooting this video going over our top 10 frequently asked questions or issues that we see come up quite a bit in our practice. So I'm going to go ahead and ask the first question, Nicole, and that is, what if our relative did not even attend the funeral?
That's a great question, Julie. There's a lot of people that will call our office and ask us questions about whether it's relatives, close relatives, even distant relatives, sometimes even family friends, whether or not they attended to the funeral and whether or not they could still inherit. And the question is, yes, they can. Depending on the situation and whether they passed away with an estate plan in place or not, the funeral does not dictate whether they would be able to inherit or not. All right, Julia, are you ready for the next question?
Sure.
All right, so what happens if there's a large family and you have clients calling in and they're telling you that they don't even know people that are on their family tree, or the people that they're contacting, they don't even know the deceased relative? What do we tell those people?
Yeah, that is another one that comes up quite a bit. And this happens with really large families. And in the case, sometimes we're going several generations down from the decedent. The family keeps getting bigger and bigger. And sometimes one side of the family does not know the other side. This may be because of a rift somewhere in the family history. You know, one side of the family doesn't talk to the other side of the family anymore. Or it could just be space or geography, and you just don't know, your cousins or second cousins, that kind of thing. But again, that doesn't impact someone's right to inherit. If they are entitled under the laws of Michigan by blood relations, then they're going to get an equal share as much as other people that are in their same position. For instance, cousins, they're most likely going to inherit the same amount as the other cousins. So whether or not they knew the decedent or whether they were involved or close with the decedent really does not dictate their rights to inherit. Okay, so the next one we've got here is, what about, my brother never really helped take care of mom. I took care of her all by myself without any contribution from him. He didn't help out financially or with time, running errands or anything. I took care of all that stuff for mom.
That's another one that comes up quite a bit, especially with siblings that are not close, or even sometimes siblings that aren't very close, whether it's geography or not. But again, this is another question where it depends on if there was an estate plan in place or not. The brother may still inherit a large chunk under an estate plan, but he also would inherit without an estate plan, depending on the law of Michigan. All right, so the next question we have is, my dad's wife is trying to take my entire inheritance. She's taking all the money and all of the assets in his accounts. What can I do?
Okay, so this is a tough one. And so in this question, I'm just going to assume that the dad was on a subsequent marriage. This is somebody's stepmom, and it sounds like they maybe did not have a great relationship with that step parent. And first of all, I try to gently point out, even though you may not have strong feelings for this individual, or you may even feel that your parents' marriage was not a great marriage, or maybe you didn't feel that the new spouse treated your parent that well. The bottom line is that this person was someone that your parent chose to engage in this relationship with and put them into a position of legal standing in their life by being married to them. They chose to marry that person. They did not choose to divorce them. So upon their death, they were married, and that person has certain rights. And in a lot of couples, the assets are owned jointly. That's very common. So when one person passes away, when it comes to a jointly owned asset, the surviving person is the full owner of that asset. And then even if there were assets that were owned by your parent individually, under Michigan law, the other, the spouse, the surviving spouse, is entitled to the bulk of the estate, and in many cases, the entire estate, just by their standing as a spouse. So this depends a lot on the specific situation. And so you would certainly want to at least consult with an attorney to find out if there is anything that you can do or if you have any rights. But often the spouse is entitled to the assets, whether they're a joint owner or they're going to inherit from their spouse. Yeah, that is a really common one. Okay, so here's one for you. Say your dad was suffering from dementia, and so there's no way that deed or will is valid.
That's another good question that comes up more frequently than you would think. A lot of the times when we meet with clients for estate planning purposes, as an attorney, we need to establish whether that person has the ability to sign an estate plan, their will, their trust, among other things. So we do check to see if that person has capacity to sign. And in the instance of someone who has dementia, that doesn't preclude them from ever being able to sign an estate document. They may have a lucid moment here or there, and at that point we may be able to meet with them and establish that they have capacity to sign at that moment in time. That just because they have dementia, again, is not a precluding factor. So this was just part 1 of our frequently asked questions, and please stay tuned for part 2. Check in to see 5 more questions that frequently come up. Thank you.